I am a little confused because Mr. Pritam Singh says, let's continue the debate. Ms. Sylvia Lim pointed out that it was premature. I would like to clarify with Ms. Sylvia Lim whether she meant that this matter is sub judice and therefore we should not be discussing this.
Sir, I did not use the word sub judice. That was not my principal objection. My objection is that the judgment is being appealed to the Court of Appeal, and the Court of Appeal may reverse the findings or review and vary the findings of the High Court. So it is premature for the DPM to file this motion to call upon the House to do anything when the findings are subject to review. That is my objection.
Well, I thank Ms. Lim for her clarification. You confirm that this matter is not sub judice, right? In your view. Do you confirm that this matter is not sub judice, in your view?
So my objection is based on the procedures that are available for parties to appeal. I have not taken a position on sub judice. It all depends on how the debate turns.
Well, I want to remind the members of this House when I spoke about the motion, I said this motion is about what is to be expected of members of Parliament: integrity, honesty, and being truthful in Parliament. So can I ask Ms. Lim, is this a proper subject for debate in this House?
If you wish to reply, Ms.
Mr. Speaker, I thought I made myself quite clear in my speech, which was focused on the fact that because the High Court judgment is going to be appealed and the findings in that sense have not been finally decided, it is premature to call upon the House in the terms of the motion. So the operative clause, of course, is the last one, where it calls upon AHTC to take certain actions. And that is the operative clause, and I'm just saying it's premature.
DPM.
Well, you mentioned about what is interim. So let me repeat myself. I said this motion is about what is expected of members of Parliament: integrity, honesty, and being truthful in Parliament. Now, this House needs to agree on the principles that all members of Parliament must adhere to, and the standards of probity required of all MPs in dealing with public funds. And there are serious issues of probity, accountability, and the handling of public funds that must be addressed now, even while the appeal is being dealt with. There is a judgment of the High Court which stands until the appeal is heard. The question is, what should be done, what should happen between now and the time when the appeal is decided? And that could be some time yet. So in the interim, my question is, should the Workers' Party town councillors who have been found to have acted dishonestly and have been found to be in breach of their duties, whose conduct was found to be egregious, should they continue to have access to and control public funds? Yeah. So members will know that when there are similar findings are made in any corporate setting, it's only right and proper that those whose integrity has been impugned to step aside and recuse themselves until they clear their names. So I welcome the efforts of the Workers' Party MPs to clear their names, but until they do so, they have to be accountable to this House for the findings that the High Court has made. And that must be doubly so when you are dealing with millions of dollars of public funds. So I'd like to ask the Town Council Chairman, what is your view on this matter? That you are the Chairman of the Town Council, you have to decide.
Deputy Prime Minister Heng Swee Keat's filing of this motion at this point in time is telling but premature. Let me explain why. The PAP government is clearly excited about certain findings and comments contained in the High Court judgment issued on 11 of October, and these are findings in relation to certain actions taken by some of us in the aftermath of the 2011 general election. However, as DPM himself pointed out, Singapore has a court structure that subjects High Court judgments to possible appeal to the Court of Appeal. And this avenue of appeal enables parties who are aggrieved by judgments of the High Court to seek review of the findings by the Court of Appeal. The Court of Appeal, consisting of at least 3 judges of appeal, will review the findings at the trial and may affirm, reverse or vary the findings. And if I may quote from the Supreme Court of Judicature Act, it is stated that the Court of Appeal may draw inferences of facts and give any judgment and make any order which ought to have been given or made, and make such further or other orders as the case requires. So the judgment referred to in this motion was delivered on 11th of October, and under the applicable procedures, any party who is dissatisfied with the judgment can file a notice of appeal within 1 month. In this case, the deadline for filing the appeal is 11th of November, which is next Monday. We have been studying the judgment with our lawyers since it was released, and I can inform the House today that we have decided to appeal the judgment to the Court of Appeal. We are still within the time frame to do so, and it will be filed by 11th of November. Accordingly, the DPM acted prematurely in its decision to file the motion, and I ask the House to reject it. Mr. Speaker, as members of Parliament, Mr. Lau Tia Keng and I have duties to discharge, and this motion appears to be aimed at curtailing us from discharging our duties while the case is still pending for final adjudication. We are still pursuing the matter through the courts, and we thank everyone who has stood by us and helped us in our quest for justice.